Okay, going to finish part 2 of Salerno. Decision maker by clear and convincing evidence that no conditions of release can reasonably assure the safety of the community or any person. While the government's general interest in preventing crime is compelling, even this interest is heightened when the government musters convincing proof that the arrestee already indicted or held to answer for a serious crime presents a demonstrable danger to the community. Under these narrow circumstances, society's interest to crime prevention is the greatest. On the other side of the scale, of course, is the individual's strong interest in liberty. We do not minimize the importance of the fundamental nature of this right, but as our cases hold, so we're balancing right now. This isn't a balancing analysis. But as our cases hold, this right may, in circumstances where the government's interest is sufficiently weighty, be subordinated to the greater needs of society. We think that Congress's careful delineation of the circumstances under which detention will be permitted satisfies the standard when the government proves by clear and convincing evidence that that's the standard, that an arrestee presents an identified and articulable threat to the individual or the community. We believe that, consistent with the Due Process Clause, the court may disable the arrestee from executing that threat. Under these circumstances, we cannot categorically state that pretrial detention offends some principle of justice so rooted in the traditions that conscience of our people as to be ranked as fundamental. Finally, we may dispose briefly of respondents' facial challenge to the procedures of the Bail Reform Act. To sustain them against such a challenge, we need only find them adequate to authorize the pretrial detention of at least some persons charged with crimes. Whether or not they might be insufficient in some particular circumstances, we think they pass that test. As we stated in Shaw, there is nothing inherently unattainable about a prediction of future criminal conduct. Under the Bail Reform Act, the procedures by which a judicial officer evaluates the likelihood of future dangerousness are specifically designed to further the accuracy of that determination. Detainees have a right to counsel at the detention hearing. They may testify in their own behalf, present information by proffer or otherwise, and cross-examine witnesses who appear at the hearing. The judicial officer charged with the responsibility of determining the appropriateness of the detention is guided by statutorily enumerated factors, which include the nature and the circumstances of the charges, the weight of the evidence, a history and characteristics of the putative offender, and the danger to the community. The government must prove its case by clear and convincing evidence. Finally, the judicial officer must include written findings of fact and a written statement of reasons for a decision to detain. So it's more than just a standard. There's several factors to be met and a written statement of reasons. Hey, we think these extensive safeguards suffice to repel a facial challenge. The protections are more exacting than those we found sufficient in the juvenile context, see Shaw, and they far exceed what we found necessary to effect limited post-arrest detention in Gerstein v. Pugh. Given the legitimate and compelling regulatory purpose of the Act and the procedural protections it offers, we conclude that the Act is not facially invalid under the Due Process Clause of the Fifth Amendment. Respondents also contend that the Bail Reform Act violates the excessive bail clause of the Eighth Amendment. So that's part B. Now we're going to dive into issue number 2. The Eighth Amendment addresses pretrial release by providing merely that excessive bail shall not be required. This clause, of course, says nothing about whether bail shall be available at all. Respondents nevertheless contend that this clause grants them a right to bail calculated solely upon considerations of flight. They rely on Stack v. Boyle, in which the court stated that bail set at a figure higher than an amount reasonably calculated to ensure the defendant's presence at trial is excessive under the Eighth Amendment. In respondents' view, since the Bail Reform Act allows a court essentially to set an infinite amount for reasons not related to the risk of flight, it violates the excessive bail clause. Respondents concede that the right to bail they have discovered in the Eighth Amendment is not absolute. The court may, for example, refuse in capital cases. So, underlining that and just further discovering that as unwrapping that, unwinding that. And as the Court of Appeals noted, the respondents admit a court may refuse bail when the defendant presents a threat to the judicial process by intimidating witnesses. Respondents characterize these exceptions as consistent with what they claim to be the sole purpose of bail, to ensure integrity. They agree that a primary function of bail is to safeguard the court's rule in adjudicating the guilt or innocence of defendants. We reject the proposition that the Eighth Amendment categorically prohibits the government from pursuing other admittedly compelling interests through regulation of pretrial release. The above quoted dicta in Stack v. Boyle is far too slender to read on which to rest this argument. The court in Stack had no occasion to consider all defendants to bail, because the statute before the court in that case, in fact, allowed the defendants to be bailed. The holding in Stack is illuminated by the court's holding just 4 months later in Carlson v. Landon. Didn't know about that case. In that case, remarkably similar to the present action, the detainees had been arrested and held without bail pending a determination of deportability. The Attorney General refused to release the individuals on the ground that there was reasonable cause to believe that their release would be prejudicial to the public interest and would endanger the welfare of the safety of the United States. The detainees brought the same challenge that respondents bring to us today. The Eighth Amendment required them to be admitted to bail. The court squarely rejected this proposition. The bail clause was lifted with slight changes from the English Bill of Rights Act. That clause has never been thought to accord a right to bail in all cases, but merely to provide bail. Shall not be excessive in those cases where it's proper to grant bail. When this clause was carried over into our Bill of Rights, nothing was said that indicated any different concept. The Eighth Amendment was not prevented Congress from defining the classes of cases in which bail shall be allowed in this country. Thus, in criminal cases, bail is not compulsory where the punishment may be death. Indeed, the very language of the amendment fails to say all arrests must be bailable. Carlson v. Landon was a civil case, and we need not decide today whether the excessive bail clause speaks at all to Congress's power to define the classes of criminal arrestees who shall be admitted to bail forever. For even if we were to conclude that the Eighth Amendment imposes some substantive limitations on the national legislative power in this area, we would still hold that the Bail Reform Act is valid. Nothing in the text of the bail clause limits permissible government consideration solely to questions of flight. The only arguable substantive limitation in the bail clause is that flight. Not be excessive in light of the perceived evil. Of course, to determine whether the government's response is excessive, we must compare that response against the interest the government seeks to protect by means of that response. Thus, when the government was admitted that its only interest is in preventing flight, bail must be set at a court of some designed to ensure that goal and no more. We believe that when Congress has mandated detention on the basis of a compelling interest other than prevention of flight, as is here, the Eighth Amendment does not require release on bail. So part 3, in our, I already read this, which is the outcome and holding. But again, in our society, liberty is norm, and detention prior to trial without trial is carefully limited exception. We hold that the provisions of the pretrial detention in the Bail Reform Act of 1984 fall within the carefully limited exception. We are unwilling to say the congressional determination based as it is upon that primary concern of every government, concern for the safety and indeed. So the dissenting opinion, Marshall, Brennan dissent. Not going to be able to get to that because class is beginning, but Stevens also dissents. So there's 3 dissenters I see here.
This is funny. Okay, hold on a second. Let me find share the screen.